Friends, today we shall deal with emergency provision under the Constitution. Means a sudden event or situation requiring immediate action. To start with, the Constitution of India in Part 18 under the caption Emergency Provision deals with three different kinds of emergency. They are Proclamation of Emergency under Article 352. Secondly, emergency arising out of failure of constitutional machinery in a state in Article 356. And thirdly, financial emergency under Article 360. The federal features of the Constitution changes and it became a unitary constitution during the proclamation of emergency. This is justified with reference to Article 250, where the Parliament shall, when a proclamation of emergency is in operation, have the power to make laws for the whole or any part of the territory of India with respect to any matter in the state list. Therefore, state list is in fact abolished during the proclamation of emergency, and the state's power of legislation is assumed by the Parliament, including imposition of duties of the matter in the state list. By virtue of Article 353, while a proclamation of emergency is in operation, the executive power of the Union shall also extend to giving of directions to any state as to the manner in which the executive power of the state is to be exercised. Further, Article 355 casts a duty to the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the Constitution. If the President is satisfied that a grave emergency exists whereby the security of India is threatened by war or external aggression or armed rebellion, he may make a declaration to that effect in respect of whole of India or of such part of the territory thereof as may be specified in the proclamation. Therefore, a state of emergency exists under the Constitution when the President makes a proclamation of emergency. An actual occurrence of war or any armed rebellion is not necessary to justify a proclamation of emergency issued by the President. The President may make such a proclamation if he is satisfied that there is an imminent danger of such external aggression, but no such proclamation can be made by the President unless the Union Minister of Cabinet rank, headed by the Prime Minister, recommend him in writing that such a proclamation should be issued. A proclamation issued may be varied or revoked by a subsequent proclamation. Every such proclamation must be laid before both the Houses of Parliament and shall cease to be in operation unless it is approved by the resolution of both the Houses of Parliament within 1 month of the date of issue. Secondly, the proclamation will get a fresh lease of 6 months from the date it is approved by resolution of both the Houses of Parliament. The proclamation will terminate at the end of 6 months from the last date of such resolution. Thirdly, the President must issue a proclamation of revocation any time when the House of People passes a resolution disapproving the issue or continuance of the proclamation. As laid down under Article 358 of the Constitution, while a proclamation of emergency is in operation, declaring that the security of India or any part of the territory thereof is threatened by war or by external aggression, the 6 freedoms guaranteed to the citizens by Article 19 are automatically suspended. Therefore, the freedoms of speech and expression, to assemble peaceably and without arms, to form association or union, to travel freely throughout the territories of India, to reside and settle in any part of the territories of India, and to practice any profession or to carry on any occupation, trade or business will remain suspended when the proclamation is in force. This Article 358 provides that the state would be free from the limitations imposed by Article 19, meaning thereby that these rights under Article 19 would be non-existent against the state during proclamation of emergency. This is important to note that Article 358 is confined to the cases of emergency on the ground of war and external aggression. Therefore, Article 358 is not operative in case of emergency arising out of armed rebellion. Article 358 suspends the 6 freedoms, but Article 359 is an additional curtailment that may be imposed by the President by order relating to other fundamental rights which is indicated in the order. Article 359 applies to emergency on the grounds of war, external aggression as well as armed rebellion. Under Article 359, the fundamental right as such is not suspended. The suspension is the right to move the court for enforcement of the right. The 44th Amendment of the Constitution, 1978, made the Articles 20 and 21 sacrosanct and beyond the power of the President to suspend the enforcement of these 2 rights, that is, protection against double jeopardy, protection against ex post facto criminal laws, and protection against compelling a person to be a witness against himself, and protection of the life and personal liberty except in accordance with procedure established by law. Even when a proclamation of emergency is in operation, access to courts cannot be barred to enforce a prisoner's or detainee's right under Article 20 and 21. One of the important things to note is that neither Article 358 nor 359 shall have the effect of suspending operation of the fundamental right unless the law which affects the aggrieved person contains a recital to the effect that such law is in relation to the proclamation of emergency. The first proclamation of emergency under Article 352 was issued by the President of India on 26th of October 1962. The reason for issuing such a proclamation was the Chinese aggression to Nepal. A presidential order was issued under Article 359. Under that order, when a person is arrested or imprisoned under the Defence of India Act, he would not be entitled to move any court for the enforcement of any of the fundamental rights under Article 14, 19 or 21. The proclamation issued lasted for 6 years and was revoked on 10th January 1968. The second proclamation of emergency was made by the President on 3rd of December 1971. The reason for issuing such an order was that Pakistan waged an undeclared war against India. This presidential order suspended the right of any detainee under the Maintenance of Internal Security Act 1971 to move any court for enforcement of fundamental rights under Articles 14, 21 and 22 for a period of 6 months or during the continuance of the Proclamation of 1971, whichever expired earlier, while the two preceding proclamations under Article 352 was issued on the ground of external aggression. The third proclamation of emergency was made on 25th of June 1975 on the ground of internal disturbance. The situation said to be an internal disturbance was that certain persons have been inciting the police and the armed forces in their discharge of duties and their normal functioning. The proclamation was revoked in the year 1977. The term internal disturbance occurring in Article 352 was substituted by the term armed rebellion in the year 1978 by the 44th Amendment Act. The resultant effect is, after 1978, it is not possible to issue a proclamation on the ground of internal disturbance. An emergency under the Constitution, popularly known as President's Rule or PR, is the emergency arising out of failure of constitutional machinery in a state and is contemplated under Article 356 of the Constitution. This power can be exercised by the President when a report is received from the governor of a state or otherwise and is satisfied from the report that a situation has arisen in which the government of a state cannot be carried on in accordance with the provision of the Constitution. By issuing a proclamation, the President may first assume to himself all or any of the functions of the government of the state and all or any of the powers vested or exercisable by the governor or anybody or authority in the state other than the legislature of the state, except the power of the High Court. Secondly, declare that the powers of the legislature of the state shall be exercisable by or under the authority of the Parliament and may suspend in whole or in part the operation of any provisions of the Constitution relating to anybody or authority in a state. Any such proclamation may be revoked or varied by a subsequent proclamation. Every proclamation under this article shall be laid before both the houses of the Parliament and shall accept where it is a proclamation revoking a previous proclamation cease to operate at the expiration of 2 months unless before expiration of the period it has been approved by the resolution of both the houses of the Parliament. A proclamation so approved shall, unless revoked, cease to operate on the expiration of a period of 6 months from the date of issue of the proclamation. However, by resolutions of both the houses of the Parliament, the proclamation will continue, but in any case will not be in force for more than 3 years. Even if a lifespan of 3 years could be given by the resolution of both the houses of the Parliament, the continuance in force of a proclamation shall not be passed by both the houses of the Parliament beyond the expiration of 1 year from the date of issue of such a proclamation. A resolution can be passed by both the houses of the Parliament for continuance or continuation of the President's rule for a longer period than 1 year in the following cases. Firstly, when a proclamation of emergency is in operation in the whole of India or any part of the state at the time of passing of such a resolution. And secondly, the Election Commission certifies that the continuance in force of the President's rule is necessary on account of the difficulties in holding general elections of the Legislative Assembly in the state concerned. Under a proclamation, in case of failure of constitutional machinery, the state legislature would be suspended and the executive authority of the state would be assumed wholly or partly by the President. That is the reason that this kind of emergency is popularly known as imposition of President's rule. The President may be authorized by the Parliament to delegate the powers so conferred on him to any other authority specified by him and subject to such conditions as may be imposed. The President may authorize, when the Lok Sabha is not in session, expenditure from the state consolidated fund pending its sanction by the Parliament. From the records, it is found that the power under Article 356 has been used 96 times during the first 42 years of the working of the Constitution. This is the third kind of emergency that can be proclaimed under the Constitution of India. Since the coming into force, till date, this provision has never been used. It is laid down under Article 360 that if the President is satisfied that a situation has arisen whereby the financial stability or credit of India or any part of the territory thereof is threatened, he may make a proclamation or make a declaration to that effect. The consequence of such a declaration are that the executive authority of the Union shall extend to the giving of directions to any state to observe such canons of financial propriety as may be specified in the directions. Any such direction may also include a provision requiring the reduction of salaries and allowances of all or any class of the persons serving in connection with the affairs of a state. A provision requiring money bills or financial bills to be reserved for the consideration of the President after they are passed by the legislature of the state. The President can issue directions for the reduction of the salaries and allowances of all or any class of the persons serving in connection with the affairs of the Union, including judges of the Supreme Court and the High Courts. The duration of such a proclamation is that it will ordinarily remain in force for a period of 2 months, unless before the expiry of that period, and it is approved by resolutions of both the houses of the Parliament. The proclamation may be revoked by the President at any time by making another proclamation. So friends, we shall conclude by mentioning that the justification of empowering the President to issue proclamation of emergency is that the Union is given the duty under Article 355 to protect every state against external aggression and internal disturbance, to ensure that government of every state is carried on in accordance with the constitutional provisions. It is also to be noted that when the country is engaged in war due to some external aggression, a unity is required and people have to sacrifice their right to some extent in the interest of the survival of the country against the threat. The Indian federal structure is in abeyance and the center-state relation undergoes a change. The normal peacetime distribution of the legislative power is suspended. So this much for today. Thank you very much.